Well, why would Pickering apply to Justice Kavanaugh's crossing himself example? I guess let's imagine it's just a free exercise claim. Have we ever applied Pickering balancing? I don't think anybody, let's just posit that in Justice Kavanaugh's example, the coach visibly crosses himself, visible to everyone, but that no one would mistake that for government speech. It's quite clearly just the private devotional practice of the coach. Why would Pickering apply? Have we ever applied Pickering just a straight up free exercise claim?
No, but this court has made clear that that's the mode of analysis for all First Amendment claims. It's done it not just with the free speech clause, but also with the petition clause by way of example. And to draw a different line would yield bizarre, impossible results. Let me give a couple of examples of what that might mean. Suppose that an assistant district attorney objects to the DA's request for the death penalty in a case, and so writes a letter to the editor, complaining and calling the district attorney out for that. Now, on Mr. Kennedy's test, that would be a classic Pickering example if it's a political view or a social view, but it would be subject to strict scrutiny if the motivation for that same letter is religious.
Suppose that everything about this case is exactly the same as it was in reality, with this one difference. When Coach Kennedy went out to the center of the field on these two occasions, all he did was to wave a Ukrainian flag. Would you have fired him?
It's not a question of firing, and in fact, he was put on paid leave.
Would you have done to him what you did to him here? Would you have treated that case differently?
That's absolutely something that can and should be disciplined, because the school district doesn't want its event taken over for political.
Where is a school district rule that says that?
The school district has to be able to manage its activities and events, and that's clear under this court's
What reason is there to
jurisprudence.
believe that you would have treated that case the same way?
There's not only is there nothing to suggest that it wouldn't have, but it would be absurd to think that a teacher or coach could take over the biggest school event of the year and in front of the students be plumping for a political cause or agenda. The school district has to be able to say.
Well, what is there in your explanation for the adverse action that you took that would support doing whatever you did to Mr. Kennedy in that situation?
Oh, well, there was an entire course of conduct here, right? The school district sent Mr. Kennedy a letter on September 17th saying, you can pray, including where it's visible to students, just don't pray with and to the students. For a month, he was having prayers at the games and it wasn't a problem. Then he sent the letter on the 14th demanding to go back and do what I was doing before, which is audible prayers. Students have to be able to join. And then he went to the press and he said, this is how I make these kids better people. And then came the game on the 16th. The idea that the school district couldn't do something when a zoo was created on the field is unimaginable.
Can a school district take adverse action against a coach or a teacher because the coach or the teacher, on purely private time, not on school premises, not when this coach or teacher is discharging any official duties, is very, very visibly religious, posts all sorts of religious messages on YouTube? Maybe this coach is an ordained minister and preaches, and the school district says, this goes too far, this is not the kind of mentor we want for our students. Can the district do that?
Usually no, but it's not an absolute, and that's why Pickering is flexible. Let me give an example for why that would be the case. Because, look, students' views of what is official and what is compulsory.
And your district came really close to the Ninth Circuit in its earlier opinion, thought that that was a justification for what the school district did. Kennedy's not a good mentor for the students.
what the Ninth Circuit clarified in its second opinion what it meant in its first. But the real point is that to students, whether the coach is acting as a coach doesn't turn on the niceties of government speech doctrine. Suppose that the coach on his personal Facebook page says, in my 20 years as a coach, I have never had a student do well or make varsity who doesn't pray with the team before every game. That's a situation that it's surely private, but it's also surely coercive. It raises Establishment Clause concerns
Well, that's a
and
different,
all
that's
sorts of
different
other
from,
concerns.
That's different from my example.
Pardon?
That's different from my example because there's quite an express statement that you better pray and agree with my religious beliefs, or you're not going to get a starting position on the team.
What that shows, though, is that there certainly can be private speech that puts on improper pressure on students to conform religiously or otherwise, and also, and that's why the test has to be practical and functional. There can't be this categorical. On Mr. Kennedy's view, there would be that's not just private, but there's also strict scrutiny, and that would make an impossible standard for school districts to deal with these real problems.
Well, I don't really understand
the answer.
Suppose the coach has got all sorts of political signs on the front lawn of the coach's house. They fire him for that reason?
No, but no one would view that as government speech, number one, and no one would view that as a message being conveyed to students, something that they might benefit from or are supposed to go along with.
No student could think that. No student could think that if I don't agree with, if I don't say things in class, write things in my papers that agree with the coach or the teacher, or I say something that's contrary to what this teacher feels really strongly, that's going to hurt me.
The question,
no student could think that?
The question isn't whether no student can think it. The question is whether a reasonable observer should think it. It's an objective test. And compare that situation with, for example, the teacher putting up those signs in the classroom. That shows that the school district could certainly be concerned about that pressure on the students, that they feel like if they don't voice the opinion that's up on the wall there, that they might be penalized for it. And the district can make the decision that that is going to regulate that, which will require, on the one hand, if that is private, recognizing the very serious First Amendment interests of the employee, but also recognizing the need to not to have material disruptions in class, the need to avoid coercing students to adopt a particular political or social view, or interjecting the dissension in the school that may cause.